Let's go to the fifth ground, which is commission of a crime or offense against the employer or any immediate member of his family or authorized representative. The nature of this ground is that the act committed by the employee is tantamount to a crime. It is a crime against person of the employer or his immediate family members or authorized representative. As law student, we know what are the crime or crimes against persons. Then if, for example, if the employer was attacked by the employee, there was attempted murder or homicide, as the case may be, then the employee can be terminated based on this ground. So what is required here is the commission of the act. Again, it doesn't require conviction, because what is required is only the mere commission of the act. The rule is still the same. Even exoneration in criminal case is not a bar to termination based on this ground. As law student, you also should know what is the meaning of the fourth civil degree of consanguinity or affinity. Because if the crime is committed beyond this parameter, then you cannot use this ground. You should not be confused with the wordings of the labor code regarding the crime or offense, because I think the framers of the labor code were thinking that crime and offense could be used loosely. So let's focus on the crime against person as defined under the revised penal code, not under a special penal law. Now the last ground would be analogous cases. What are these analogous cases? The Supreme Court, citing the ground of gross inefficiency, also in one case of International School Manila versus International School Alliance, February 5, 2014, the Supreme Court equated gross inefficiency as analogous to the foregoing. So it is analogous to gross neglect. So we have two cases saying that the Supreme Court ruled that gross inefficiency is considered gross neglect, and you also have gross inefficiency as analogous to the foregoing. What I am referring to is the case of Piliti versus Barbano. However, it was dated November 27, 2009, where the Supreme Court said that gross inefficiency is gross neglect. This recent ruling of International School Manila is dated February 5, 2014. So we will use this prevailing ruling that gross inefficiency is considered analogous to gross neglect. If we look at the date when the decision or the two decisions came out. So if you'll be asked in your bar examination as to gross inefficiency, do not use the old ruling that it is gross neglect of duty. So you will use that gross inefficiency is analogous to gross neglect. There was the case of an employee who stole the credit card of his co-employees. According to the Supreme Court, it is analogous to serious misconduct, so the employee was validly terminated. That is the case of John Hancock Life Insurance Corporation versus Joanne Country, September 3, 2008. Then there is another case of Fagliarni and Gapos versus San Juan de Dios Educational Foundation et al., September 14, 2016, where the Supreme Court ruled that unauthorized selling of textbooks in violation of school manual is considered willful disobedience or conduct analogous thereto, so the employees were terminated. Lastly, in the last bar examination, there was the question of bona fide occupational qualification. It is a ground to terminate an employee based on analogous cases because it is analogous to willful disobedience. As we all know, this was the case of Irastogi versus Philippine Airlines, where flight crew were required of standard weight, body weight, in order to fully function inside the aircraft in times of emergency and other situations. Here is the employee who did not pass the weight standard prescribed by the Philippine Airlines, so the employee was terminated. In this case, the Supreme Court upheld this bona fide occupational qualification rule, where the employers are given the leeway to prescribe a reasonable weight requirement in order for the employee to continue employment. So since the employee did not comply here because the employee has become obese, it is a ground to terminate according to Supreme Court for being analogous to willful disobedience. The order of the Philippine Airlines is considered legal, valid, and reasonable. So since the employee did not lose weight and pass the standard, the employee can be terminated.